Start. Respondent borrowed a sum of rupees 1,50,000 from the appellant herein on or about 10th August 1999. Stop. On a demand having been made in that regard by the appellant, the respondent issued a check for the aforementioned sum on or about 20th December 1999. Stop. The said check was presented by the appellant to the Oriental Bank of Commerce, Delhi, but the check was received back by the appellant with remarks insufficient funds. Stop. Para. A complaint petition was filed by the appellant against the respondent for alleged commission of offences under Section 138 of the Negotiable Instruments Act and Section 420 of the Indian Penal Code on 29/1/2000. Stop. He also filed a suit for recovery of a sum of rupees 2,04,000 on 19/10/2002 in the Court of Senior Civil Judge at Delhi, which was marked as suit number 253 of 2003. Stop. Para. Both in the criminal as also in the civil proceedings, the defense raised by the respondent was that she had not taken any loan from the appellant as alleged or at all. Stop. It was furthermore asserted that the check issued by her was not in respect of repayment of any loan, since no such loan had been taken. Stop. Para. Respondent urged that the appellant had met her husband, who was a property dealer in connection with some business, who made a representation that pertaining to the same deal the police had to be bribed. Whereafter on 10/8/1999, the appellant, accompanied by one Miss Malhotra, retired ACP, and his son, came to the office of her husband and forcibly took the check in question from her husband, since the check book was with him. Stop. Para. By reason of the judgment dated 26/9/2003, the learned Sessions Judge recorded a judgment of acquittal in favour of the respondent, holding that he had successfully proved that the check in question was not issued to the complainant by way of repayment of any loan. Stop. Para. Respondent thereafter, during the pendency of the trial suit, filed an application in the said civil suit purported to be under Order 7, Rule 11, read with Section 151 of the Code of Civil Procedure, for rejection of the plaint on the ground that the criminal complaint had already been dismissed. Stop. Para. The learned civil judge dismissed the said application inter alia, opining that the findings of a criminal court in the proceeding under Section 138 of the Negotiable Instruments Act would not operate as res judicata in the civil suit for recovery of money, as the nature of proceeding in both the cases was different. Stop. Respondent approached the High Court in a writ petition questioning the order of dismissal of the said application and praying inter alia for the following reliefs: Para. To set aside and quash the impugned order dated 17/3/2007, passed by the Honorable Court of Civil Judge, Delhi, in suit number 356 titled as supra, and pass such other further orders as this Honorable Court deems just and proper in the facts and circumstances of the matter. Stop. Para. By reason of the impugned judgment, the High Court allowed the said writ petition. Stop. The High Court, in arriving at its finding, applied to the principles of res judicata. Stop. It also opined that the suit filed by the appellant was nothing but an abuse of the process of law. Stop. Para. Mr. J. M. Kalia, learned counsel appearing on behalf of the appellant, would contend that the High Court committed a serious error in passing the impugned judgment insofar as it failed to take into consideration that the principle of res judicata is not applicable in the facts and circumstances of the case. Stop.